Watching News at Prime, let's get into another important conversation. The Supreme Court of Appeal has overturned former ANC member of Parliament Bongani Bongo's acquittal. The impeached Western Cape Judge President John Hlophe cleared Bongo of charges relating to an alleged attempt to bribe a former parliamentary law advisor, Nthuthuzelo Vanara, to collapse the proceedings. These were parliamentary proceedings. Let's discuss this now with News 24's legal journalist, Karyn Maughan. Karyn, good evening to you and thank you for your time. Let's take the viewer back a few steps here. This was concluded some 3 years ago. How did matters unfold in court, very briefly?
Remember, this was a matter that occurred in 2017, towards the end of former President Jacob Zuma's tenure in office, where there was this full-scale investigation into alleged wrongdoing in Eskom, driven in part by, of course, the Gupta leak emails and allegations of corruption and malfeasance. Essentially, what had happened was that Advocate Vanara was intended to lead the parliamentary inquiry investigation into Eskom, and he alleged that he had been approached by Bongani Bongo and asked to fake an illness or collapse the inquiry because so-called quote-unquote Eskom people were concerned about the implications of that inquiry. And he essentially said that Bongo had said to him that he could name his price if he did so, but his integrity would not allow him to participate in such a manifestly corrupt enterprise. And he immediately reported what had happened to a number of his parliamentary colleagues. Ultimately, however, Judge President John Hlophe found that these colleagues' versions of how that event had been recounted to them were inconsistent, and he found that Vanara's evidence about what had happened, including his testimony about not a direct amount of money being offered and no bank details being asked for, made his evidence somewhat uncredible, and he effectively, without ever expecting Bongani Bongo to take the stand, granted him a Section 174 discharge because he found that the state had not produced enough prima facie evidence to justify a response from him. Now, the Supreme Court today found that that finding was founded on a number of legal mistakes, mistakes of law, and that effectively John Hlophe hadn't even understood the nature of corruption, what is required to prove it, when he made that judgment.
Very interesting turn of events. I want to go back to what you have just said, Karyn, and that is the Supreme Court of Appeal saying today that John Hlophe made, and I quote your article now, multiple mistakes of law when he acquitted Bongani Bongo. Did they go any further in explaining what some of these multiple mistakes of law were?
Well, one of the things that they brought up was, the former Judge President's interpretation of the Prevention of Corrupt Activities Act, where he said that in order for corruption to be proven, the mere collapsing or discussing collapsing of an inquiry would not be enough, that an explicit amount needed to be offered in order for it to be said that that was a corrupt act. And the court found that this was simply not the case, that in fact Vanara had testified that it had been offered a sort of blank check arrangement, and the fact that bank details were not exchanged did not necessarily disprove that an allegedly corrupt event had occurred. They also found that Judge Hlophe had been wrong to say, for example, that he had dismissed the state's attempt to appeal the judgment immediately after he gave it, and one of the reasons that he gave was essentially that Bongo could raise a double jeopardy argument if he was subjected to a retrial. And John Smith, who was the judge in the SCA who gave that ruling today, saying this is simply not what the law says. So there were a number of examples raised by the state. I think the state had cited 9 examples of mistakes of law that they said Hlophe had made, but the court really confined itself to 2 or 3 issues that they said were so grave that they justified a retrial and essentially invalidated that Section 174 discharge.
So if a court comes to such a decision that a retrial ought to be had, who then must carry the responsibility of representing, if I could term it that, representing evidence before court? Is it presumably the NPA?
Yes, absolutely. Now, remember, the National Prosecuting Authority was the entity that actually bought what they essentially did was they said they wanted to reserve certain questions of law that they alleged John Hlophe had got wrong. Now, we have seen that before, Cloete. I mean, you and I will both remember with the Oscar Pistorius culpable homicide finding, the NPA did exactly the same thing, but they said in that particular instance that the questions of law that were reserved were in relation to Judge Thokozile Masipa wrongly finding Oscar Pistorius guilty of culpable homicide when he was in fact guilty of murder under the principle of dolus eventualis. The case here is somewhat different because the judge in this case has said that were it not for the mistakes of law, committed by Judge President John Hlophe, it would be very probable or possible that Bongani Bongo would have been convicted, certainly in circumstances where he didn't defend himself. So it is now up to the National Prosecuting Authority. I have contacted them. They say they will, when a decision is made about when that retrial will happen, they will release a statement. I don't know if Bongani Bongo will launch any type of appeal, but given the lack of success Oscar Pistorius had in relation to his case in doing so in the Constitutional Court, I don't think his chances of succeeding in the apex court are very good.
Sure. And as you say, Karyn Maughan, in your article that this was a unanimous judgment by the Supreme Court of Appeal, and to your words, they saying that there are, quote unquote, reasonable prospects that Bongani Bongo could have been convicted here. This was a trial relating to corruption. If indeed it does come to that, how many years behind bars could Bongani Bongo possibly face if convicted?
He faces 15 years behind bars. That's the minimum sentence, unless the court can find substantial and compelling circumstances justifying the imposition of a lesser sentence. So it is a very serious offense. He is facing another prosecution in a different jurisdiction, as I understand it, also for alleged, corruption or malfeasance. And this is a very serious matter for him. He hasn't at this point said what he intends to do. But we know that he has, used Mike Helens, who of course was representing the Gupta family, is one of the best criminal defense lawyers in the country. And if he has to go through a retrial, which is a very unusual thing in South African law, we don't see it a lot. I think they will be very aware of what evidence the state intends to lead against them, and they will be very aware of how they'll need to counter it. So certainly from their side, they will say that the outcome of this case is not a foregone conclusion. But what the SCA said today was that if at that stage of the case, Bongani Bongo had essentially closed his case, he was very likely to have been convicted of the offense of corruption.
A very interesting turn of events. One question I've got to put to you. The impeached judge, John Hlophe, he was judge president in the Western Cape. Yes. He came to this conclusion. Now it has been overturned. A panel of judges at the Supreme Court come to a unanimous decision that this must be a retrial. What does that say about the reputation of Judge John Hlophe? This is someone that is held in high esteem by many South Africans who say some of his cases are now quoted as case law because of how brilliant a judge he was.
Well, it's not the first time that Judge President John Hlophe has been chastised by the Supreme Court of Appeal. In one instance, he granted an in-chambers reversal of an NPA's freezing orders of the assets of Mr. Malotsi, who was facing allegations of fraud by Old Mutual. And he did that without reading the National Prosecuting Authority's papers in regard to why those assets needed to be frozen. In that case, the subsequent head of the investigating Directorate, Hermione Cronje, was representing the NPA, and he was chastised by the Supreme Court of Appeal for granting an in-chambers order to a person who was being represented by his personal attorney at the time. He was also very heavily chastised in relation to that now notorious New Clicks judgment, which related to the pricing of pharmaceuticals, and his decision and the decision of his colleague were overturned, and the minority decision of Judge Jeanette Treverso was upheld, and certainly his conduct in that matter was very heavily chastised by the SCA. So certainly it is not an unusual thing, and I think that while many people do support John Hlophe, the courts certainly have had a lot to say, including the Constitutional Court in the Joe Slovo informal settlement matter, in regards to his appreciation for the rights of displaced people. The courts have had a lot to say about how he chooses to adjudicate against in certain cases, and certainly this judgment will join the ranks of those judgments that are not very favorable about his particular brand of jurisprudence.
Karyn Maughan, legal journalist with News 24, thank you very much for your time and insight here.